Hello, my name is Ray Hill, and the name of the program is PAPA. Now, that's not a generation or a sexual role to play. PAPA stands for Public Access Public Affairs. It's an acronym. And I do this show periodically, and hey, I'm glad to see you tuned in. A lot of you got invitations from me, and it's good. See, I can look through the camera and actually see you through your television, so I know who's out there, and I really appreciate your tuning in tonight. This is a very important program to me. As you know, I do a radio show called executionwatch.org, and some of the times you see Execution Watch programs on HMS TV because every time we interview the inmate, we not only shoot that interview with the inmate with a camera, but we also shoot the whole show, and then that gets all put together and it shows up here at Houston Media Source in the regular rotation of programs. But I've got with me the lawyers from the legal team on Execution Watch. And I thought it was about time that that audience, as well as you, saw them and watched them think. Now, on Execution Watch, what I usually do is I make an introduction and then I turn to my right and I say, Jim, and I'm going to do that today. Jim, what are we doing?
Let me explain why this program is important. Those of you who are not familiar with law, there's something like almost 20 crimes in Texas that are capital crimes. Let me tell you what a capital crime basically means for those of you not familiar with law. A capital crime in Texas is only two alternatives if you're found guilty, and that's a capital murder, and either you get death by injection or death by nature, because you're going to get two sentences, death by ejection or life without parole. And the only difference between the two is you die slower, perhaps, by nature if you don't get the needle. So anytime you're found guilty of a capital murder, you're going to die and never get out of prison alive, period. Now, there's a thing called non-death capital, and that's when they file a case as a capital murder, but they're not seeking the death penalty. And again, this is even more draconian. The only remedy if you're found guilty is to get a life without parole sentence, which is in fact a death sentence. I mean, they keep harping about how wonderful it is that our Texas has quit executing people. They're executing them differently. They're executing them by nature as opposed to a needle. Now, let me tell you why that's dangerous and why that's really bad. Because if you have a real triable case in a murder case, but it's a capital case, you cannot afford to gamble to go to trial if there's a chance of being convicted. And what happens, the prosecutors use non-death capital as a means to work out a plea bargain agreement, and it pretty well destroys your right to a jury trial, because if you lose in your case, your client's going to spend the rest of their life in prison. So as a result of that, what they're going to do is work out a plea bargain with you, and then usually that's about 30 or 40 or 50 years when we work out those plea bargains. It knocks you out of any chance at all of trying a case. That's why it's dangerous. Now, here's what bothers everybody at this table. Number one, the agency or the group who makes that decision is a prosecutor. Now, every prosecuting office does it differently. Harris County, for example, they'll have a committee that will decide, but it's a committee of other prosecutors. Let me tell you the problem with that. The problem with that is real simple. Most of the people who are prosecutors come straight out of law school, have never defended people in their lives, and don't know anything about what it's like on the streets. They become prosecutors. And the big problem with Houston is that our DA's office is in fact and really not a prosecuting office, it's a law firm representing the police department. As a result of that, the tail wags the dog. And we can't go into all the reasons that's true, but there are many reasons that's true, is that because in our DA's office, there's that marriage between the DA's office and the Houston Police Department. So in what really results, in fact, when you look at these capital cases, is the police along with the DAs are the one that make this decision to seek the death penalty. And like I say, the penalties are terribly, terribly harsh, because the minimum you're going to get if you go to trial is death by nature, and it's a death sentence. And that's why this is an important program to discuss the discretion on the part of prosecutors.
Thank you, Jim. As a matter of fact, during the course of the show, I'm going to make Jim the prosecutor so that he can play that role for you. And you know, the fact of the matter is, most wrongful conviction cases begins when one cop turns to another and says, I've got a hunch about this case. And from there, everything goes downhill because they stop investigating the case and they start putting together evidence to prove that hunch. But I'm going to set this up. Now, for tonight's case, involves the robbery of an Asian-owned convenience store in Channelview, Texas. And the assailant, the guy that does the robbing, is a white male, late 20s, early 30s. And he walks in the store alone. He's got a gun. He robs the store. He gets the loot, and he shoots the clerk, killing him. Goes out, gets in his car, and speeds away. Now, the car is gone, but somebody in the store got the license number and called the police, giving them the license number simultaneous with the report that went out over the radio or the computer. And the car was spotted right away. They read your license plate through the computer so they know who you are. And in the car, they found the assailant, the loot, the gun, and a passenger. They arrested both of them. Jim, you're the prosecutor, how does this case get to your desk?
Gets to my desk is really simple. What happens when a police officer makes a case, the first thing they do is again call the DA's office, called DA's intake. And the person working that desk, they'll recommend certain charges to be filed, and that's one of the problems, in my opinion, with this system, because rather than giving them an offense report and let them study it without the pressure of the police officer wanting to prosecute a case or wanting to push a case, it ends up oftentimes doing what the police want to do. Like I say, the tail wags the dog in many of these cases.
And so this is the elements of a capital case. The police say, we want a capital murder case filed on it.
It becomes a capital murder case because if you commit a murder during the course of a robbery, that's a capital murder case automatically. And the big decision at that point is how to file it. And they usually always file it as capital murder on both people, even the passenger. They normally do.
Why do they do that?
They do that primarily because they want to work a deal with the guy that's the passenger, to work a deal with him, to get him to testify against the other shooter. That's what they usually want to do. And you'll see this oftentimes in capital murder cases. The guy with the strongest case, they'll oftentimes work a plea bargain out to get the guy with the weakest case. And they do that as a plea bargaining technique. Now, the way you nail the passenger, there's a thing in law called the law of parties. Now, if you're not the shooter in a case like this, you can be held guilty of capital murder if you can anticipate when you plan the robbery that someone's going to be killed. If you anticipate that somebody could be killed during your planning of a robbery, then you can be held guilty of capital murder for robbery if the killing occurs. And that's easy to prove, because if you and I decide to rob a place, I know you've got a gun and I'm sitting in the car, I can anticipate that someone's going to get, you don't take a gun because you take a gun to kill somebody. So you can anticipate that. I can anticipate that, and therefore I can be held guilty of capital murder. In fact, in Florida, there's a case not too long ago where the guy sitting in the car who did not do the killing was on death row. The actual shooter had gotten a life sentence and was paroled out and was out on the streets when this guy was executed.
And they executed him anyway.
Absolutely executed.
As a matter of fact, you always give me the example of the Charles Manson case.
Well, people complain about the law of parties. What I've got to prove as a prosecutor is that this person sitting in the car did something to aid or assist. Now, it can be as little as helping me plan the robbery. For example, if you were the killer shooter, if I set up the robbery ahead of time and gave you the layout of the place and provided you the gun, that would make me a party to the crime. Or if I assisted you during the robbery by keeping lookout. But you've got to prove I did something. Merely being present is not good enough. As a prosecutor, I've got to prove that passenger did something to aid, encourage, or assist in that murder case. If I can prove that, then he's guilty of capital murder, although he's not the shooter.
Okay, that's the prosecution side of the beginning of this case. It's going to last the whole show, so stick around, make yourself comfortable, get to where you enjoy this. It's going to go the whole show. Now let's build a defense side. Larry, you get appointed to represent the perp, the guy with the gun. What's the first thing you do?
Well, first of all, several things have already happened on the prosecution side. Sometimes in death cases, the prosecutor actually go to the scene, and they start building the case right away. So from a defense perspective, your hope is that your client did not talk, because part of the process of building the case.
Well, both of these guys, the perp's been to prison. He's been handled before. He's got enough sense to keep his mouth shut. The passenger has been on probation. He's got enough sense to keep his mouth shut. So you don't have that complication. You got a videotape, a gun, the loot, the car. Does that help you?
It helps, but my concern is what really happened, and I'm not sure if I'm representing the shooter or the passenger now.
You're representing the shooter.
Okay. Let me just talk a little bit about the passengers for a minute, because we're talking about the law of parties.
Well, I'm going to appoint Janik to be representing the passenger.
Okay. The law of parties, there's got to be some showing of what the other party did. But if you're representing the shooter, then it's just a matter of trying to figure out again what happened was the incident occurred. There was a prosecutor, likely even at the scene, but they start putting the case together as quickly as they can. The defense lawyer, once the defense lawyer finally does get appointed, there's probably some things that have already happened that the defense lawyer does not know about. So the first thing the defense lawyer has to do is find out whether there are any possible defenses. So that's a matter of finding out what does the state say happened at the scene. Was there an intent to rob? I don't know what happened. I mean, the facts are very
I understand. I
sketchy.
understand what you're searching for. Somebody. This is a difficult case. You didn't want this case. It was appointed to you, fell in your lap, and you got to deal with it because that's your profession.
Really, there's only two defenses, Larry. Either self-defense or his accidental shooting, that you intend to do it. You got to go with on 10 on the mens rea.
Yeah, but we don't know any of that.
And that's your defense. You've only got two defenses to a murder. Well, really three. It wasn't me, but that's going to be knocked out. Number two, the next thing you're going to have to do is say, well, it was self-defense. That's your other shot. The third thing, I didn't intend to do it. I stumbled and fell and the gun went off accidentally. That's about it. Those are your only defenses, because you've got a video, you've got to call it with the loop.
I'm trying to find out how Larry gets information. You've got to have an investigator to go to the scene and investigate. How do you pay for that?
You want to get as much information as you can yourself. You want an investigator, but you want to be there yourself. As I mentioned, the prosecutor is probably going to go to the scene.
Yeah.
The defense lawyer has to go to the scene on a case like this. Also has to get a lot of background information on the mental state, whether the defendant is even competent whatsoever. That's one of the first. So you'll try to get doctors appointed to find out what his mental state was. You try to figure out what can they prove actually happened. As Jim mentioned, is there anything that can be used based on the facts to contest the issue of intent? Did he really intend to rob? Did he really intend to shoot? I don't know what those facts are, but those are the kinds of things that I would begin to, that the lawyer would need to begin to attack, to find out, is there anything any evidence that I can develop from the scene that would allow me to develop a defense for him.
Is there any concern on your part about the chain of custody of the videotape?
Not really, Ray.
That's a red herring.
Unless there's
nothing that could be in there that could get you to go to the court and get it excluded.
Well, you'd want to get the videotape to review it yourself to see exactly what happened. But if it reasonably reflects what occurred, then that chain of custody issue is
It's just a red herring.
It's not as important as it used to be in the past. I mean, the fact is, if it reasonably represents the occurrences on the date that the incident occurred, and it would be of help to the jury, of aid to the jury in understanding the case. But the other thing is, there might be, you want to look at the video yourself, because there might be something in the video that actually helps you.
Now, you can't be lawyer to both of these guys.
Absolutely not for
Because there's a conflict of interest there.
There is a conflict in any two co-defendants. So I'm talking about even the
Absolutely.
shoplifting cases,
Okay.
you can't represent both. But in a case like this, that will just, there's no way it's going to happen.
Let me mention one thing you asked. You asked about excluding the video. That's impossible. The reason being, in order to exclude evidence, you got to have standing, meaning some right's been violated to kick it out. This video belongs to the store.
Yeah.
No video is going to be excluded. Now, you may exclude parts of a video because there may be things that are inadmissible, but this defendant has no standing to contest that video because he has no standing, because no right was violated of his when the video was made. So there'll never be a chance of the video not coming in.
But that's an important issue.
Absolutely, it's an important issue.
And I think Ray was mentioning something about whether there was a chain of custody issue that would allow you to exclude the video, and there is none.
Okay. Okay, Janet?
Yes, sir.
Yannick, you get appointed to represent the passenger.
Okay.
What's the first thing that comes to your mind?
Well, the first thing that comes to my mind is to introduce myself to my defendant and to have him sign the appointment form and give him a business card and tell him to keep his little mouth shut.
Okay, suppose he's got that down. He's been silent so far, and he says, Ms. Yannick, I haven't talked to anybody about anything, although the detectives wanted me to. I haven't talked to the detectives, and I haven't talked to the state's attorney. Can you help me?
Well, of course, I can attempt to help you. I can't make any guarantees. But yes, I can help because I can come to the jail and we can speak one-on-one. We're not going to speak in the holdover back and forth. I'm going to read to him the DIMS report from the district attorney's office, which they file when they file any felony case. They have a brief synopsis of the facts. I will read him the DIMS report. I'll ask him about obvious things like prior convictions. How many do you have? What for? I will ask him if he has ever received any medication for mental illness. Does he have a history of being diagnosed as either mentally ill or mentally retarded? And I'll do all this in the holdover, and then I will go speak to the judge and speak to the bailiff in the courtroom and ask them to please have him segregated apart from his co-defendant, the shooter, because I don't want...
Are both these cases assigned to the same court?
Yes, of course.
Why?
Well, because it is one fact situation. It came in on the same day. And when you have a felony case with multiple parties, all the parties are in the same court.
It's called a judicial economy is what it amounts to.
Judicial economy?
Yes, where they don't have to have separate trials and separate courts, do it all at one time. That's what they've justified.
And so as a result, I would talk to the bailiff and I talked to the judge about my perceived need at this moment to segregate my defendant from the shooter. Because one, I want to protect him. Two, I want to make certain that nobody is talking back and forth between them. The fact situation is nebulous at this point. I don't know enough about the facts. I do not have a full offense report. I may have just a brief summary of an offense report and the DIMS, and that may be all that I have at this point.
Do you have access to the DA's file?
Oh, of course. But the DA, at the very beginning of an appointment, will not have a full offense report themselves.
Larry, do you have access to that file?
Oh, absolutely. And I don't want to keep stepping on Paige's toes, but in terms of the law of parties,
Yeah.
they have to have some evidence to show that he actually did something. Being,
Right.
like Jim mentioned, mere presence is not enough. So under the law of parties, for instance...
It's enough for the charge. It's not going to be sufficient for conviction. Is that what you're saying?
Exactly, but you start to look at what does the evidence, what can they even prove? So, I mean, just being in the car is not enough. So for instance, if we plan the robbery together, if the two people plan the robbery together, if they can prove that, that's enough. But let's just suppose that I'm sitting at my house, the co-defendant, the passenger, and this guy comes by and picks me up.
Before or after the robbery? Doesn't matter.
Let's say before the robbery even.
It makes a big difference.
And he's not, if you can prove after the robbery, then that makes a clear difference. But if it's before the robbery, but the passenger doesn't know. We're on our way to a party. He said he had to stop by the store and pick up something. I had no idea he was going to do any of that. They have to prove that he did something other than just be there. So there's law of parties, but the law of parties requires that the person who is charged actually did something. And if there's no evidence that he did anything, you start really pushing hard for a
There's
dismissal.
more than that. They're going to prove he did something, but could have anticipated, not only do something, but should have anticipated a killing would occur. Just doing something, you got to do more than that to get a capital murder case on a non-party, on a non-shooter.
Well, that's a conviction, but it doesn't affect the charge, does it?
It doesn't affect the charge. Well, it does affect the charge. You can be found guilty of straight murder if you can't prove that he anticipated that your death would have occurred.
Okay.
You got a
Now,
number one.
So
Right, he's
prove
got
I
to have.
did something,
There's got to be
I
a proof that he did something
That's
criminal.
right.
Yeah, absolutely, yes. But if
Okay.
he didn't do anything at all,
Okay.
if he didn't even know,
do you want these cases tried together?
no, absolutely not.
Janet? You
No,
want
sir.
No, sir. No way.
No, I'd rather not.
Okay. So you're trying to not only get the cases tried separately, are you trying for a different judge in each case?
We won't have that option.
It's not
No,
available.
sir.
Okay. So separate trials. Suppose the state comes to the passenger guy and say, "Look, you don't really have much on your client." They come to you and say, "We don't have much on your client, but how about non-capital life in exchange for testimony against his co-defendant?" Are you obliged under the law to tell your client of that offer?
Absolutely.
Well, first off, I wouldn't do it. Let me tell you why. The strong case is on the shooter, not on the party. The weak case, you're not going to go to the weak case. If you're going to work out a plea bargain agreement, you're going to work out the one that's got the weakest case. I would never offer a deal to the guy with the weak case. The guy really that did the shooting is a lay-down cinch, a retarded
They don't need
monkey.
his testimony
We don't need
in
his
this case.
testimony. So why try to work a deal with her?
Well,
I wouldn't work a deal
but
with
the
her.
point is, I have the obligation to convey every offer to my client.
Offer wouldn't be made to you is all I'm saying.
No,
Yeah,
I agree.
But
It
if
would
it
never
were
happen.
in the imaginary world, if you was such an offer, you'd have to. And when you told him about the offer, what would you advise him?
Oh my goodness. Well, I would not advise him to make any decision yet because I haven't talked to him fully about the facts.
Okay, you would. Time is on your side.
I have got to go to the jail and I have got to talk to him about the facts before I can even assess whether or not an offer.
Time is on your
fair.
side, right?
Yeah, at this point.
Larry, is time on your side?
No. But let me make sure we're clear now. Now, Paige's client is the
Passenger.
the one against whom the case is weakest.
Yes.
Okay, and so my guy, I mean, the state would want her client's testimony against my guy. I would think that because they really want this guy to fry.
Yeah.
Why would they want it? They got enough already with that.
I know, but they really want him to fry.
I don't. Well, all we know is that there's been a killing, but I'm not sure what all the other facts are. If
Well, neither am I.
The only reason I'd offer a plea bargain to Paige if I thought that we couldn't make a capital
Right,
murder case.
right.
If I couldn't prove that, number one, that he did some overt act to help,
Exactly.
and number two, he couldn't anticipate the shooting, I'd offer a plea bargain to her. But under these set of facts, the idea that a jury would believe that somebody's picked up somebody and casually went by and robbed and killed somebody, no one's going to believe that. But if I had a weak case against Paige, I'd offer a plea bargain. That would be the only reason.
Okay.
I don't need her testimony.
Okay, so the offer's made. The family, he tells his family, and she's not giving advice because they have to have some more conversation, but she's had to tell him, so she explains it to him, and he goes to his family and says, this is a court-appointed lawyer. She's in with the state. She's selling me down the river. Wait, stop, okay? So the family gets
could
together,
happen.
$2,500, and goes and sees Mike. Mike, these are your people. They're in Channelview, Texas.
They're my people.
And so Mama and Daddy come into your store in their overalls and their flour sack dress, clutching a valuable $2,500, and they say, Mr. Gillespie, we don't trust this court-appointed lawyer. Will you help us on this case? Mike, what are you going to do?
It's a common problem. People don't trust court-appointed lawyers. My problem is that if I've got a difficult case that I got to try, I'm looking for a court-appointed lawyer to help me. You know, the trouble with trying lawsuits, you can't just try one. You got to try a lot, and you got to do it all the time.
For $2,500?
We're not getting into the
Slow
money.
down a bit.
We're not talking about the money. All I'm saying,
Jack wouldn't.
Can you do anything for these people that Yannick
yes,
can't do?
yes, I can.
No, I would.
Okay.
Yes, I can.
What can you do for them?
I can help her. For $2,500, I can help her. Maybe she needs witnesses. Maybe she needs investigators. Maybe she needs somebody to talk to.
And you probably dealt with members of both families before.
And they trust me.
Yeah.
By trusting me, they listen to me. And when I talk to her and she tells me the law and I understand it, all I got to say, it's okay, and it's okay. But they don't trust her because they haven't sat with her and talked to her. And she hasn't helped her with the kids and with the families and with the probate. I have.
You're the neighborhood lawyer
They
there.
trust me. And just like a doctor, I'm the general practitioner. But when you need brain surgery, I know the brain surgeons. When it comes to trying lawsuits,
You know the brain
I
surgeon.
know who tries lawsuits. And I'm telling you, a lot of lawyers get a couple of victories and they think they're hotshots. The trouble with this business is I can be 19, 20, playing college baseball and hit the fastball.
Okay, so you and Yannick hook them up.
Well, no, you got to
And
be
you-
careful because a lot of lawyers, they don't like somebody looking over their shoulder watching what they do.
What do you think, Yannick? You think you do a little help?
Well, if he wants to volunteer,
How much are you getting paid on this case?
oh, I'm being paid by my court appearances
Some
and
change.
by my out-of-court hours. And my investigator is going to be paid at a rate based upon the judge's discretion. But it would not be, well, I don't know any lawyer that would take a co-defendant in a capital case for $2,500. But if somebody wanted
That's all these people have got.
well, but if somebody wanted to volunteer to assist me and they were being paid by the family because the family wanted to hire them, based upon my relationship with him, perhaps we could help each other.
Okay.
You see, and that's the beautiful part about this.
Yeah, so there's a
want
little
trust.
camaraderie going on amongst the lawyers too, that you can share responsibility. Is that true, Jack?
Ray, let me back up just a little bit. I get this question an awful lot, and I spend a fair amount of my time dissuading people who can't afford a good attorney, dissuading them to talk them into holding on to the court-appointed attorney that they have. And this is the way I go about it. If you have a car, you need a car, you buy a $500 car, with absolute certainty, you bought a hunk of junk. However, if somebody gives you a car, it may be a good car, it may not be a good car. You don't know until but if you, I don't care if you spend $500 or $1,000 or 50 cents on a car, it's still real money. If you paid nothing for the car and it breaks down on you, you got all the car you paid for. You paid nothing, you got nothing. You paid some money for a car, it's still money, and you're still angry. The last thing you want to do is pay an attorney your life savings, and your life savings isn't very much, for an attorney who, frankly, is just there to cash in.
And Ray, the other thing is we're talking about the court-appointed system, and judges have no desire to appoint lawyers who can't handle the case. Now, we've got court-appointed lawyers who are qualified for different levels of offense.
And you got qualified
The
capital
qualified capital,
Yes,
the
indeed.
qualified capitals are the cream of the crop in Harris County in terms of handling capital cases. The other thing is that they're fairly reasonably well paid. The difference between first, second, and third degree felony appointments and capital appointments is night and day.
Oh, well, of course.
Night and day. Okay, and the court's going to appoint capital qualified first chair and second chair.
and secretary. You get 2 lawyers if it's a capital case.
You're going to get 2 lawyers who are both capital qualified, 1 qualified first chair, 1 qualified second chair, and the payment is decent for the amount of time. And those lawyers, the judges will allow them to even have additional pay based on what they're doing. So while the case is going to follow them for the rest of their lives, a lot of times the cases outlive the lawyers. But the appointed lawyers in capital cases are good lawyers in terms of they've been qualified to handle capital cases.
They're exceptional lawyers.
Okay, Jim, what does a capital case cost?
It varies from place to place. In fact, there have been appointed lawyers on capital cases that charge $100,000 for trial fees. And there have been several of them that got $100,000 in trial fees, and that's just for the trial. Then you got to pay for the case going up on appeal. Now, let me tell you one thing everybody's overlooking, and I think it's critical. Nobody's talked about it. From my viewpoint, the critical thing you got to do immediately is decide whether this case is triable or not. This case is not triable for your client.
Right.
Your case may be triable for your client. Now, as a prosecutor, what I want to do is save a lot of time and effort. As soon as you find that case is non-triable, you should approach me immediately. Time is more important than all of you have given it credit for, because if you decide, you can decide. It doesn't take a genius. Once you kind of get the facts about even the very beginning of the case, to know if you got a video, you got the loot, got caught at the scene, the gun, that you can trace the gun to ballistic, that's a dead man. You know that going in. You don't need to hire a genius to figure that out. If you think that case is non-triable, the way to get a good plea bargain from me is come to me, so I'm going to have to spend a lot of time and money. If I have to put a lot of effort into this case, I'm going to seek the death penalty. It's out of honoriness, probably. But it's real critical that you make the first thing you've got to do when you make that initial investigation is ask myself, can I afford to try this case? Because if you guess wrong, your client's going to be dead. And if you think it's non-triable in your case, the first thing I would do is crawl in bed with the state and try to work a deal out and save me a lot of work and a lot of effort, try to work a good plea bargain.
So it becomes about efficiency of the operation of the court and efficiency of the time for the prosecutor.
The law, you got a lot of cases if you're going to do, I got a lot of cases to handle.
Yeah.
And if I
12
can
homicides
save some
that day.
time, if I can save some time and get rid of a case, because, and this is a horrible thing to admit about our system, and we all know this, our system is geared on, you always hear these guys, our docket is clear, we're always worried about dockets, as though that's the court's calendar, as though there's some docket archangel watching over you.
Yeah.
There's a lot of pressure to push these cases, there's tons of them. I mean, there are case after case. I got a stack of cases this high to try. If you'll come to me before I do a lot of work on it, I'll be much more generous in working out a plea bargain than if you make me work a whole bunch and ignore my other cases. I'm going to be cranky about it. So I think the first thing you've got to do is decide, number one, is this a triable case? Let me give you some suggestions from experience. The way to do that, if you think it's non-triable, the first thing you do is just simply lay out in writing all the bad facts about the case. Get the family together and tell them ahead of time, this is what the state is going to prove. And in all likelihood, if they prove, we got a video of your son doing the shooting, we got the loot inside the car, we got the gun, ballistics that led to it, they're going to convict him. If they convict him, he's going to die. But we can work this case out and get them to go with you to talk to your son, the one in jail. You want to, because remember, you've got to save people's ego, because if somebody's in jail, he's probably told his parents he didn't do it. You got to get them, save their ego, and get the family to help you persuade this person that the thing to do is get a plea bargain. You've got to plea bargain your case. At least Paige has a shot at it, but your guy is dead meat, and I know that.
Well, clearly the shooter is the job of the defense attorney for the shooter is to try to keep death off of it.
Yeah,
Exactly.
That's the primary
And if you'll come
job.
to me ahead of time and save me a lot of trouble, I work my other cases, I'm going to be generous with the plea offer. If you make me work a whole lot and ignore my other cases, I'm going to punish you for doing that.
Exactly.
That's the way it works.
The other thing is when you go to the prosecutor after having visited with the client and his family, you've also got to give the prosecutor something for the other side, because the dead person, that person has a family too, and the prosecutors listen to that person a lot. So it's a matter of dragging that family through a trial. You've got to give them some reason as to why, because they've got a case where they can get a guy dead if they want to.
Yeah, but Mike over here represented the kid's father in 3 cases.
And that becomes the problem. If I'm here and they're coming to hire me, and because we never talked about money.
This is a family case for you.
Let's assume they have lots of money. Let's assume it's not $2,500. Assume they say whatever you need.
We'll sell everything and give it to
The
the law.
problem I've got is what Jim said is absolutely right. The most important thing to do is analyze your case, find out what you got, and approach the DA.
Are there circumstances where you would turn down that money?
Don't like the people.
No. Are there circumstances?
If I cannot relate to them, if I don't feel that we're communicating, they need,
you
your lawyer-
would not say, I can't help you any better than Yannick can.
Oh, no, I would say that. But what I do believe is they deserve me to find out about the case,
I've done that before.
give my opinion about the case, to vouch her opinion. You know, the other problem with what Jim just said is true. The way you would handle a case, a court-appointed lawyer, is right off, you look at the case, you see what you got, you know the DA because you work in that court, work it out.
Yeah, we see one another every day.
I come in and they're paying me. If they give me money and I go to court and work it out, I'm going to get something on me because I took the money and didn't do anything. In addition, when that case is tried, might be a stranger. They might know me, but court-appointed lawyers work in that court. You can see the chemistry between somebody the court likes and somebody, me, who's coming in replacing somebody the court likes. And all of a sudden, the jury picks up on objections, and they pick up on things like
Jack,
that.
you've actually turned money down, right?
Oh yeah.
I do it all the time.
Yeah, I do
All
it
the
all the
time.
time.
I think that from our viewpoint, one thing that irritates me as a prosecutor, and we know this, we pretty well know the lawyers that chisel people.
Yeah.
It's absolutely.
You know who can try a case and who
absolutely.
cannot try a
It's
case.
absolutely. I've seen lawyers charge giant fees and go to trial and do stuff that's absolutely unnecessary to justify their fees. The way you should charge things, and of course I work for the government.
Sure.
But the way I would charge if I was a defense lawyer is on what the work you do. If you can't help, you shouldn't charge people for it. And I've seen people do that over and over again, and I love to get those folks in trial. I like to hammer their heads and tell you the truth.
How do you know till you talk and find out what the police report says, what the DA wants?
In this case, it's
She can't
simple.
talk to me.
I know from Larry's case, he's got a dead client. I know that. That's not hard. Her's the problem. But him, I've got nailed. And so I don't care if you hire F. Lee Bailey and charge $10 million.
You got a videotape.
Because he's dead. Even if they didn't have the video, Ray, you've got the loot, you've got the car, you've got the gun, they did the shooting, the ballistics. It's a joke. I mean, he's dead meat, and I know that.
Okay, in the plea bargain with Larry's client, okay, we're looking for a courtroom bargain here. We're going to plea bargain this out because I don't have to do all this work, and the court doesn't have to do all this work. We're not going to burn up all this money and time, and so we're going to plea bargain him. And is it possible for the passenger to get more time than? culprit?
Possibility, but probably not, because here's a problem as a prosecutor. When I make a deal with Larry, I'm giving a price on that case. When I say this case is worth 40 years, 30 years, I couldn't go to Page and say it's worth more, because I set a price on that case by the bargain I make with him. So when I make a bargain with him, I got to look at Page's client and saying I've got to give her something at least as little as I gave Larry's client or less, because I had put a price on that case by the amount of deal I worked with Larry.
But that's
And I'm not simple-minded. And so if he has put a price of 40 years on the shooter, there is absolutely no way I'm going to talk to my client about a
Getting
plea
more time.
bargain that involves
Okay,
getting
so your
40
client,
years.
said, no, I'm not buying 20 years, and makes you go to trial. What are y'all going to do?
That's the problem. That's how
Happens.
it happens. If you get paid to come in, you almost have to try the case, and then you can get more time than the person who took the plea.
If you get paid to come in, you have to
It's
try.
not, you're not gonna
That's
get
what
time,
I'm
you're
saying.
gonna
You
get
have to
killed.
try to justify your fee, and that's not always the best. If you care about your client, the first thing you want to do is talk to her to find out what's going on the case and tell her, what can I do to help? And you know, sometimes in this business, just talking with another lawyer about the case is a great help. Maybe she needs an investigator. Maybe she needs to find witnesses. Well, I can find them. The family can find them. The $2,500? Here, what do you need? You need forensic evidence? Here's some money for you. She likes me already. Look at the way she smiles.
That might help.
And I get the opportunity to maybe second share with her, to sit with her, and maybe learn a little bit
You
from
don't
her.
want to go to trial. You cannot risk. This is the bad
Agree.
thing about capital murder, because if you lose, your client is dead. Because what he's going to get at the very minimum is life without parole, and that's a death
Death
sentence.
sentence.
Of
So you've got to
course.
keep that in
Now-
mind. You can't afford to try unless
Well,
you're damn
Okay,
certain.
now stop.
Okay.
All right. If he gets a death sentence, there's automatic appeals. If he pleads out for less than that, there ain't no appeal.
That's right.
Jack?
The appeal is kind of a joke to begin with. With competent attorneys, if you don't have an appealable issue, you can throw the kitchen sink at it, and the Criminal Court of Appeals will either say harmless error or officer safety.
Of course,
they're
when they
gonna
get
say-
down
no,
into
no.
the
What
prison,
they're going to say is you've got to prove the result would have been different if you did something, the Strickland test. And there's no way, in this case, especially in Larry's case, it's going to be impossible for somebody on appeal to say the result would have been different if you did X, Y, Z. That's going to be impossible.
Sure,
gets
because the
to
case is
which
already
gets to the next
pretty
problem.
good to begin with.
When you really talk about trial work, the real key to trial work, to a real good lawyer, is not winning the case or trial, it's building in reversible error. And that's the hardest
you
thing
got to
to do.
slip
I
it in.
disagree with that. I think the real thing about trial work, number one, is to realize that you can beat the offer made by the state or beat the penalty. That's the real key to trial work, is whether or not you can
Okay.
beat the offer made by going to trial, or you can beat the offer. That's it. That's the real
But what I
case.
meant by that,
You're not going to build in reversible error that easily, believe
Well,
me.
if it's a capital case, you know there's going to be appeals, and so reversible area is something you want to think about as you're trying the case. Get the judge to fall into some traps.
well, I'm talking general.
How well do traps?
No.
Okay.
That's just, that's way too much.
Pipe dream.
Yeah.
Let's look at all the cases we tried in execution watch. All the cases we've tried, all capital murders, all going to death. Now, how much reversible error have we found in any of those cases?
Practically zero.
Zero, zip, nothing.
In every-
Because again,
Or
back
at
to
least
what
it didn't
Larry
work.
said, you got the best lawyers in Houston as general trying the case, and they know what's reversible error or not. They well know that. And why would I build in error in your case when I've got a good cinch? It would be stupid on my part to build in error. I would not do it. I'd be extremely cautious, and there would be no error. You look at all the death penalty cases tried, the number of reversals are minimal, very minimal, and it's usually by stupidity on the part of the prosecutor. So the idea you can appeal a case in a death penalty
Well,
is dead right.
given
You're
a Chuck Rosenthal, the stupid can happen in the courthouse.
But Rosenthal's not there.
I
I'm
know,
there.
but given his time,
On a practical note, though, the likelihood sometimes of getting the prosecutor to agree to take death off the table is sometimes totally impossible. sometimes if the public sentiment is such that the public will be outraged.
Okay,
The
Larry?
prosecutor might not be able to take that. Now, I'd like to share one experience. A story that a death row that a capital defense attorney told me. He tried capital cases before, even gotten not guilty on capitals, and he said that he got a capital case, and he was trying his best to negotiate with the prosecutors to take death off the table, and he was a good negotiator, but they wouldn't do it for him.
Okay.
And in the meantime, the family then goes out and hires a lesser attorney, and once that lesser attorney is hired, then the state takes death off the table. He was a bit insulted by it. He said, "What's happening here?" He says, "Well, if we went to trial with this guy, he very well might end up, the case might end up coming back because he just doesn't know what he's doing. But with you, we're going to get a sure kill." And this lawyer says, "I had to stop doing capital cases altogether because I'm doing my client a disservice, because some people, if the lawyer is not competent, he's handling the cases, the case might go on for a long time."
And this goes back to exactly what Jim was saying earlier. If the prosecutor has to invest in the case, they're going to want a larger, a pound of meat.
Yeah.
If you look at the case,
For whatever reason,
right? And if you look at the case and you realize, okay, this, here are our defenses, no defenses. All right, it's time to put my beggar's hat on and say, look, this is not a good situation for us. What do we need to do? He's very sorry. It was an accident or whatever. Whatever you can try to do to negotiate with the prosecutor in order to get the best result. That's what you should do in a case like that.
Okay.
And I'm not disagreeing with that at all.
Okay,
but
let's save both of our guys. All right? Your guy gets non-capital life. He's eligible for parole in 20 years.
None, you can't get none. If you get you get life without parole if it's non-capital. There's no such thing as straight life. It's automatic life without parole.
All
The
life
only
is the
time you
same?
can get life in a capital murder if you're under the age of 18.
I know, but the deal is they lesser included offense.
Well, you can charge him. I could reduce it to straight murder, and he could get life.
Yeah,
We do
okay.
capital.
So that's what the deal they offer Larry, and your client is pretty much obliged to get whatever they offer, right?
Okay, well, yeah. The fact is, I mean, again, I'm not disagreeing with anything Jim said, or even what.
But it's
others
all right
have
if you
said.
do.
But the concern I have is we're always stuck with prosecutorial discretion. They can do it if they want to, but in some cases they will not. In some cases, if they're dead set on having a dead body, then the lawyer has no choice other than to try the case. Or if the client, despite all of his family's concern, persuasion, decides, I'm not gonna plead, I want a trial, then he has no choice but to try the case. You do all that you can, but the overriding factor on every case, from a simple speeding ticket all the way up to a capital murder, is the prosecutor can decide that they can want to reduce it or not.
Let me
You're
follow
stuck
up
with
on
that.
what you're saying, Larry. There was you may not remember this, but in Oklahoma about 5 years ago, a prosecutor in a multiple murder case got the death penalty in one and tried him a second time and got a second death penalty.
Oh, bless him.
And that's, he said, well, why did you do it? You got a death penalty. Why did you do a second trial? He said, I want him good and dead.
Yeah.
And that's what I'm talking about, that prosecutorial misconduct, that prosecutorial discretion. Absolutely.
Yes.
Got 2 death penalties. There was a case in Huntsville where a guy was 60-something years old, and they were seeking the death penalty. If he just got a straight life sentence, he would die in prison. But it was because, you're exactly right, because of the notoriety of that case, and they wanted to. And you got to realize that DAs are elected, and you got to keep an eye on what the public wants.
All right, you guys, this is just like execution watch. The clock becomes God. So we're running out of time, and I wanted to ask you.
I thought you were.
You fellas. I mean, Paige and Mike, your guys get a 20-year offer. What are you going to do?
I think she tells me the offer, and I sell it to the clients.
She tells you the offer, and you go to the parents.
To the clients.
You start at the parents, and who are clients in this case, and you go forward.
And I
Before
tell
we
them,
And then, wait a minute, I'm not there because I'm fixing to come to you. Both of these guys go to the Ramsey, and they're doing their time, and somebody says, you ever been by the writ room? And they go in there, and there's this jailhouse lawyer.
but see, that's the benefit of me.
Wait a minute, let me get through. There's this jailhouse lawyer that says, you could have done better than that. Look for a couple of bags of coffee and a little ice cream and a Coca-Cola too. I can write you a writ that'll unravel all of that.
Throw in a back rub.
What do you? Or you can go with me to the back room. What's going on here?
You're sentenced to how many ever years? You've got nothing but time, and you're in prison. Everybody is telling you you could have done better. This could have happened. You didn't think about this. Your lawyer didn't. And for whatever reason, well, I understand why. There's this currency of, well, I know what could have happened, and I know somebody who did this, and therefore, because I know that information, I have the keys to your getting out of prison. So, in order to do that, I can help you get out of prison. This is how you do it. Your lawyer obviously was too lazy, and so on and so forth. Among other things, you need to file an ineffective assistance of counsel, and so on. You're in prison. You've got nothing but time on your hands to speculate what somebody else should or shouldn't have done. That's really what's happening.
Which is another reason I'd want to jump in a case like that for $2,500 up front.
Let me say one thing. One thing we left out. We've got groups here in town, all over Texas, that are doing this idiot stuff of charging people money, promising they can get people out of prison. It's a big scam.
Yeah, it's a big scam.
A big scam. They've got groups doing that.
Yep.
And they're
Send me $465.
No, they're charging $4,000. One group out of Austin is.
Yeah.
My goodness.
Yeah, but they're having to compete with one another with their scams.
It's just a simple promise that we'll do something. And they know good and well that nothing can happen, or that the likelihood is so
nothing to lose,
astronomically
really.
small.
The
What
thing
can
I
you lose?
don't understand is true criminal lawyers, you're ripping off criminals? It seems to be a dangerous job. It seems to be not they're not a real criminal lawyer if you're playing these games with your clients.
Well, you'd need to
don't
talk to an
know.
ex-mayor of Pasadena about that. I think.
How about Tommy Shazer? You guys forgot. He's a lawyer that we probably don't know. He got shot.
Yeah.
Because he was.
Scamming them.
Not a lot of
There's one thing I
future
want
in
to
it.
say before we go. You know, I kind of like what they do in England, where they have the barrister and solicitor system, where there's two types of lawyers. There's a lawyer that takes the case in, deals with the families, prepares the case for trial, does all the work, and then there's a litigator. And all he does
He
is
takes
gets
the
file
notes and he
does-
goes, it's
but
kind of like
that-
me on execution watch. I take Elizabeth's notes and make radio
But
out of it.
that's all he does. He does it every day. That's all he does. And meanwhile, he has a reputation of winning. You know, when it comes to prosecutors, the way you get a deal, you beat them.
Well, the
you can
prosecutors
beat 'em-
rotate too over in
I
England.
know, but your word
And so
gets
do
out.
the judges.
But then the word gets out on you. But the only thing prosecutors take seriously is they don't want on their record they lost. If you
Well,
can-
there's another side to that. Sometimes I want to make my bones. I want to try a case against a big hotshot lawyer so I can make my bones.
yeah, but that's
Yeah.
her, not me.
Well, I'm just telling you.
the
Yeah, no.
Good lawyer, maybe
What,
incentive to try the
what
case.
you're saying is your reputation is all you got in that courthouse.
That's right.
I got to talk to these people right here. You can easily see why I love these guys and gals.
Well, it's a gal there.
Yeah, the gal. And I'm a gay
Sort of.
guy, so maybe they sort that out. But you can see why I love these people because they volunteer their time. Every time we do an execution watch broadcast, Jim researches it out, shares all of his research with everybody else. Most of the time they look at other sources and come to the table well prepared, and we do that in real time while somebody in Huntsville, Texas is being strapped to a gurney and getting killed. And during the hour that we're on the air, we begin with, Jim, what happened in this case? And he tells me what happened in this case. And then we start sorting out the trial, the case, the people involved, the appeals and the appeals and the appeals. And if an interesting point of law comes up in the process, we plumb that out like we were diagramming to build a house. If it ain't there, we fill the time with conversation. But the fact of the matter is, radio, when you hear it or when you see it on Houston Media Source, it looks easy. It requires work, not only while you're doing it, but ahead of time. Execution Watch is a unique piece of media because it goes to the source and it covers the story in real time when a real human being with a real family has been strapped to the gurney with needles in his arms and they are killing him. Personally, I think executions of all kinds, either life without parole or execution on the stick, I think that's all an anachronism from a different time and shouldn't happen in the society where I live or have chosen to live. There are other societies that do it differently. Hell, a guy in Scandinavia killed the prime minister of Sweden and got 10 years, and people were complaining about why did he get so much time. A Norwegian prison is better than the motels that I stayed on while I was going to vacation last year. And their system works better than ours because they get less repeat business. Prisons are about human beings, they're about families, they're about poverty. I want to thank you for watching this show, and I want to thank these people for helping me make media that works. My name is Ray Hill. The name of the program is Public Access Public Affairs, and you will be able to find this program and the programs that were shot for Execution Watch on the archive of this station. Just go to our website and you'll find directions to our archive. It's also posted on YouTube. You can do a search on the YouTube page for Houston Media Source. I want to thank you for listening, and good night.